ABC Listen. Podcasts, radio, news, music and more.
Hi, I'm Patricia Carvelis, the host of Politics Now. The election is over, but politics just keeps on going. Actually, this is my favourite time in politics, off the back of an election where there is so much to talk about and to pore over.
Are the Liberals asking themselves the right questions? You know, we know this was not just a Peter Dutton problem. We know this was not just a bad campaign.
Politics Now isn't going anywhere. Find a new episode every day on the ABC Listen app.
When you read, watch or listen to the news, what do you really know about the work that goes on in the background to get big investigations into the public arena? Some of it is obvious. The phone calls, the interviews, the late nights, and stressful looming deadlines. But increasingly, here in Australia, more than almost anywhere else in the world, there's another side to this kind of reporting. And in some cases, it can shape the stories you see and hear before they're even published. I'm Thomas O'Reilly, and this is the final episode of Agents of Influence, a series by Background Briefing. Gina McKeon's a reporter on the story. Hey Gina, how are you?
I'm good. How are you going, Tom?
I'm well, thank you. I'm very excited to be talking to you.
You should be excited because it's about defamation law.
Oh, I am now really excited. Great, and terrified.
Yeah.
What have you been looking at?
Well, it's quite an interesting story, and I do want to start in the Background Briefing office in our little corner of the ABC.
Little corner there.
So I was sitting there researching this story one morning, and I sit across from a journalist who works in BB, Marty Smiley.
Yep.
I should be familiar with him.
I'm very familiar with
And
Marty, yep.
we're both working away on our stories for this series, and on this morning I am just working away and I hear this, and I look up and I come over and I say, "What's wrong, Marty?" And he said, "I've just got this legal letter."
So I received this at 9:12 p.m. It's been sent to the wrong email address. So I didn't get. So I'm getting it this morning.
At this point, Marty's story hasn't even been published, and so you know what his story's about.
It is an email about Sir Leonard Blavatnik, which is the man that I am profiling and doing a story on, a billionaire and oligarch. Oh man, great.
This isn't uncommon for journalists in Australia, getting legal letters. Over the years, we've been called the defamation capital of the world. At one point, we had twice as many cases as the UK, although they peaked in 2020.
Gosh, it's extraordinary, isn't it?
Yeah. And Tom, you would have seen those huge cases that had a lot of publicity, one of which was about former Liberal staffer Bruce Lehrmann being accused of rape in Parliament House.
Strapped for cash but pressing ahead, Bruce Lehrmann is challenging Justice Michael Lee's ruling that...
And Victoria Cross recipient Ben Roberts-Smith being accused of war crimes.
Sued by war veteran Ben Roberts-Smith, who claimed their 2018 reports in 3 newspapers defamed him.
There are these really big multi-million-dollar cases.
I look forward to the opportunity to finally defend my reputation.
So as I said, Australia's become known as a place where people with bruised reputations, politicians, sports players, celebrities, often people with deep pockets, battle it out with media companies.
Yeah, Gina, this is an interesting story to look at, right? Because we have a vested interest.
Look, as a journalist, I want to be the first to admit that I have a vested interest in this story, obviously.
Yeah, absolutely.
And we know that journalists sometimes tell stories not everyone wants told, and there's power in that, of course. And the people in those stories might feel their reputations being damaged as a result. And obviously they have a right to defend their reputation.
Obviously.
And when that happens, they turn to lawyers, plaintiff lawyers, who go into bat for them in court. And what people might not realise is that these cases aren't just affecting those in the courtroom. They can influence what's showing up in your newsfeed and which stories aren't. So the impact is more significant than most people might realise or understand.
Yeah, that's right, yeah.
But while we as journalists can sometimes feel hamstrung by lawyers, it's interesting to hear from the other side, because there are lawyers who actually think we, the media, have all the power. And that actually leads us back to Marty.
Okay.
Because on that letter, in the letterhead, there was a company, a law firm called Giles George. The letter is signed by Patrick George himself, one of the principals there. And it just so happened that only days before Marty had received that letter, I was actually allowed inside the offices of Giles George to visit someone else.
Wow. So what took you to Giles George?
Rebecca Giles.
Now tell me, this is a name I'm familiar with, but tell me about Rebecca Giles.
I think most journalists would be familiar with Rebecca Giles.
Yeah.
For those who don't know, Rebecca Giles is one of the biggest names in defamation law in Australia. She's a lawyer, a solicitor, and she's one of the principals at Giles George. Her firm specialises in what they call reputational risk, and she's won some big defamation cases. So I was really keen to speak with her. When I arrived, I was led into the office and then into a boardroom, and I was setting up my equipment, and as soon as she walked in, she said,
"Do you want to do it in here or you want to do it in a smaller room? Is it too echoey?"
Like, she was just really aware
that
very
you were
quickly.
recording, you needed quality audio.
Yeah,
So
very media savvy.
Yeah, media savvy and understanding the importance of the craft of journalism and broadcast journalism.
Yeah, they basically become experts in the media as well, as you'd understand. And I think some journalists become experts in defamation law as a result of these things too. But it made me really, I asked her about it. I said, how many podcasts have you done?
I've done a couple, but most of them have been about tsunami things and...
Yeah. And I thought,
Tsunami things?
Yeah, because she's a survivor of the Boxing Day tsunami.
Is that right? Wow. Did not know that.
In 2004, Rebecca was, doing pretty well. She was working as a litigator. She was working really hard and she thought, look, I'm just going to have a holiday. At Christmas time, I'm going to go to Thailand. And so in Thailand on Boxing Day, she was sitting in a bungalow on the beach. She was reading a magazine and the next thing she knew, she was just hit by this massive wave.
She was right there.
The death toll from a series of earthquakes and tsunamis across Southeast Asia and the Indian Ocean is now around 11,500, with thousands more still...
Rebecca got thrown around and she ended up on like a roof, ended up on top of this roof. And she was rescued. She was choppered out of there. When she came back, she was in a coma and she had to have dozens of surgeries to repair her body.
Dozens?
Yeah.
Wow. So do you think that her experience in the tsunami, it's driven her to be the lawyer that she is in the courts today?
Well, Rebecca's talked about how it was a really slow, long recovery. She had to work at it every day. And finally getting back to being a fully functioning lawyer was the best feeling.
I think anyone who knows me and my history will know that I'm a natural sort of born fighter.
She continued to work through her recovery and developed an interest in defamation law.
I was attracted to matters that really mattered to individuals or companies that impacted on reputation. And also seeing, the impact that vindication and restoration of reputation has on the lives of an individual. That was really satisfying. When I see an injustice, I'm compelled to assist and to act. And there was no law firm in Australia that was devoted purely to reputational risk.
And she thought, that's the thing for me. So eventually she decided to set up her own firm specialising in that area. And it was through there that she had quite a lot of success as well. She's represented some big clients like Sarah Hanson-Young, Brittany Higgins and Christian Porter. And one of the cases that she says she's most proud of is former Australia Post boss Christine Holgate.
A very strong female business leader who was very unfairly maligned in the media for a long time.
That case was a big win for Christine Holgate and for Rebecca. Australia Post agreed to pay $1 million to settle the case, along with legal costs.
I think that what she managed to achieve in relation to her exit from Australia Post was very, very significant to women.
Given the significance of some of these cases, I wondered if Rebecca thought of herself as influential in her work.
I wouldn't say that I'm influential. I can only operate within the bounds of the law. So am I very active and seek to influence on behalf of my clients? Yes. But that's just a part of my job.
On the day that I actually rocked up to the offices of Giles George, there was a thing happening called a lunch and learn. And Rebecca had said to me, you should come along to that. and all of her team are basically filing into the kitchen, picking up a sandwich and some drinks, getting ready for this lunch and learn.
This was an internal briefing. It wasn't for anyone outside apart from you. Okay.
The person who we were all there to listen to was Sue Chrysanthou.
Another name I'm very well aware of.
Sue's worked with Rebecca on some high-profile cases, but their roles are different. And they are both well known in their own right.
Sue is probably one of the best known barristers in this area.
Rebecca's a solicitor. And in very simple terms, a solicitor's role is to basically handle most of the work with clients and case prep. Barristers, like Sue, they typically work in the courtroom. They argue the case in court, they cross-examine witnesses, but they can also advise on a case early too.
They're seen as the celebrities of defamation law, really, aren't they?
They are. And when I knew that Sue was going to be there, I thought she famously doesn't give media interviews. So I thought this is a really rare opportunity. Sue walks into the offices in her walking gear as well. She famously walks 30,000 steps a day. She takes her kind of cases and a lot of her conversations on the phone as she walks.
I've heard that, yeah.
Anyway, she walks in, and as soon as she walks in, she's got this really commanding presence, right? She's talking, she's got a big voice, everybody listens.
Search engine, the new search engine defence.
And you felt welcomed in that room? Did they make a big deal about you as a journalist sitting there watching and observing?
I'm obviously a foreign body.
Yeah.
in there literally as well as a new person. It's unusual for a journalist to be let into a space like this, especially them knowing I had the recorder running. It had quite a jovial atmosphere. You know, it was lunchtime, they all grabbed a sandwich, they walk into the boardroom, Sue sits at one end, Rebecca at the other.
Okay, thanks very much everyone for coming to Lunch and Learn. We're really lucky that Sue is going to talk to us about a few update or some interesting issues in defamation law.
They're here for professional development and to get up to speed on the latest in defamation law, including this new requirement that if you're going to be suing for defamation, you have to prove that you've suffered serious harm.
So with serious harm, the wording of the legislation, which I think we've now got right in our precedents, is the plaintiff considers that he or she has suffered the following serious harm to reputation. And I think that's important to make sure you use that wording.
They also go through some recent examples to show how sometimes you get a good result even without going to court.
Remember I was writing it by the pool one night? We were late by the pool one night and I had to send this urgent notice under Section 31A.
Sue talks about how in some cases you can hold a media organisation responsible for readers' comments that appear online on their website.
The article wasn't defamatory of my client in itself, but there was a very defamatory comment.
When the client tried to use the complaints process to get it taken down, it wasn't easy.
And it took us ages to try and find an accessible complaints mechanism.
So Sue sent them a letter to get that comment removed, but actually the publisher went further.
They just thought stuff that would take the whole article down. The rest of the article was pretty boring, but very happy client. But you have no claim. That's the end of it. But it's a very quick way, it was very effective.
So, Tom, this whole scene was a really rare insight into how high-profile defamation lawyers might approach a case and how sending a single legal notice about a comment resulted in a publisher removing the entire article.
Right, so going beyond the intended outcome in a way, I mean, it shows the potential power of a notice.
Yeah, and Rebecca's sent a lot of letters. Some are legally required to put people on notice. But even still, Rebecca's heard her approach described as aggressive.
To the extent that's been said about me, well, because I have heard it before. And I think it's because when you're a senior female and you're doing that, advocating fiercely on behalf of your client, it seems as some sort of unusual quality.
Journalists I've spoken to have shared this view that her approach is aggressive. But Rebecca says she's not aggressive and that she's often met with aggression from the other side.
Well, I think that when people take issue with a step that I've taken or a letter I've sent, I just have to explain that I'm doing my job. You know, you often do get met with upset or aggression on the other side.
What's the aggression on the other side about?
Like I say, I don't think people like being held to account. I think that's very much the case with journalists.
From Rebecca's perspective, her role is to get the best result for her client and act as a check and balance on the media's power.
I think there are a number of journalists who believe that they have a higher calling or that they are true believers, that they must speak truth to power and their truth is the truth. And they don't particularly like receiving legal correspondence. I don't know anyone who does like receiving legal correspondence, Gina, do you?
But here's what's interesting, Tom. Rebecca says when clients come to her firm, they don't always give them a legal solution. She says her firm also offers what she calls strategic communications.
Strategic communication? What is that, like PR?
Kind of. Rebecca says that they might think about a media strategy and that sometimes they'll connect clients with journalists.
We have communication specialists within our firm and they are likely to do that. And it might just be an introduction.
Is that something that makes your firm different, that you do have, I suppose, a way to describe PR forward way of thinking, or that it isn't just legal advice? Is that something that sets Giles George apart?
Yeah, I think so. Absolutely.
Rebecca had mentioned a client of hers, and it looked to me like they'd kind of nailed this approach. It's Sam Fricker, the former Olympic diver.
It was a dream to make the Commonwealth Games. To walk away with a medal is just incredible.
He has a podcast called Diving Deep.
Diving Deep is about talking to high performers on what they do and how they do it.
He's done a lot of interviews with politicians.
So they were here with Australia's Federal Minister for Climate Change and Energy, with over 21 years' experience in Parliament. The Honourable...
Now, Sam Fricker did this interview with Peter Dutton, and then an article came out calling that episode a flop.
I think that, you know, the criticism of Sam about, you know, his reach as a social media influencer and podcaster was, you know, incredibly unfair.
Sam Fricker didn't sue for defamation. He did, however, release this video on his LinkedIn about the so-called flop.
This is what the Sydney Morning Herald had to say.
Where he basically addressed it all.
They went hard, calling out my podcast as a flop. But I'm going to show you the real numbers.
I thought that his response was a fantastic one. Sure, he probably could have sued for defamation over that. But in his situation, he had the tools already to deal with it. And he responded appropriately and I think hit it on the head.
This journalist failed to make clear that I actually make many clips on the podcast, and all those clips went out and actually got 1.42 million views.
And was that part of the advice that you gave?
I won't be able to talk about advice that I've given, but I think that his response in that situation was the right response.
And this is why I love social media. It gives people like you and me a voice.
What that video shows is that reputations aren't just vindicated in the courtroom. Firms like Rebecca's can advise on other ways to do this. And for clients like Sam who feel, as he puts it, unfairly maligned by the mainstream media, it's empowering.
But hang on, I mean, I thought people engaged in legal proceedings can't talk to the media, right? So how does this work?
Yeah, there is a rule that solicitors aren't allowed to be a part of getting anything published about an ongoing case that could prejudice a fair trial.
Often when litigation is commenced, there's a lot of media attention on the commencement of litigation. And look, the expected position is that litigants shouldn't be speaking to the media when cases are ongoing. So the answer is we can't. Like, you wouldn't do it at the same time.
But there's nothing that stops solicitors from engaging with the media before or after a case is resolved. And there are dedicated comms people working in those firms that handle media inquiries. So I asked Rebecca. So with your comms specialist here, for example, though, if they're not part of the proceedings, are they able to talk to the media at all about the cases?
Well, no.
If they're not party to the proceedings?
They are party to the proceedings because it's our firm. So we represent the party.
Okay. So if there's a case ongoing, no one in Giles George can talk to the media, is that right?
It's not that. So, for example, if someone contacts us and they say, is the case in court this week? We're not going to say we can't speak to you. We might say, yes, it is. But the point is that it's improper and unwise for a litigant to be making statements while a case is in court, and they could be in a lot of trouble with their judge.
And that includes everyone in the firm as part of the proceedings, is that what you mean?
Well, there's solicitors' rules that apply to making public statements in relation to cases in court. And, you know, as a solicitor on the record, it's my responsibility to ensure that doesn't happen.
While I can see why Rebecca's clients like Sam would be liking her approach, I wanted to know more about what it's like to be on the other side, you know, to be receiving Rebecca's letters. And that led me to a woman who's received more than one.
No, look, it's not pleasant.
Yes, can you translate a hollow scream?
That says it all, doesn't it?
Yeah, that was Kate McClymott's first response when I asked her what it's like to receive a legal letter from Rebecca.
So Kate McClymont, obviously a Gold Walkley Award-winning journalist with a reputation as long as this city, she would have definitely experienced the odd legal letter over time.
What plaintiff lawyers and firms have you received these kind of envelopes or concerns notices from?
Oh, just about everyone. Just about everyone.
So yes, Kate's received many letters. And when it comes to Rebecca, Kate says she's a formidable practitioner and likens her to a terrier. I put this to Rebecca.
I think it's a compliment. Coming from the equivalent of a journalistic terrier, that's probably high praise.
But back to Kate. Even despite her experience receiving these kind of letters from lawyers, she says she's still not quite used to it.
I'd honestly rather get a death threat than get a statement of claim in a defamation action. I'm serious, because it's going to tie up, months and months of your life.
Kate talks about how these letters list out what's called imputations. So things that aren't just what is explicitly said and alleged in what's been published, but implied or conveyed as well. And so these are the ones that sometimes the journalist would say, well, I never published that.
And often you find that when the concerns notice or when the statement of claim later comes in, the imputations that people claim, saying your story suggested this, and you think, you've got to be kidding. My story did not suggest that.
And Kate says these imputations can be really hard to fight back against because it's less about the words you've used and more about, to quote the Castle, the vibe.
Sometimes you read the imputation, you think, where is that in the story? But if they can get up on that imputation, it's really hard.
A lot of it sounds very subjective.
And that's what I think is the interesting part about the battlefield between journalists and plaintiffs as well. And it's sort of like, where is that line around, what the journalist's intention was with the piece and what the person at the other end of it, the plaintiff, says it was. So if the defamatory imputations get up and a judge accepts them, then the journalist may have to prove that something is true that they never intended or included in their story in the first place.
When you come to do these major investigative pieces, like in the back of your mind, you are always thinking, okay, how am I going to be able to prove that? Will the person that I have quoted anonymously, will they be prepared to waive their anonymity to come forward and give evidence?
And Kate says all of this adds up, literally.
You know that you're costing your employer a lot of money. Barristers charge $10,000 a day.
Kate says sometimes there's a pressure on the journalists to let it go.
And that's the thing that as journalists we hate most. It's sort of like you want to stick by your work, but the reality is sometimes it's just easier to say, right, okay, here's $2,000. Let's drop it.
It's what journalists and lawyers working in defamation say is part of the so-called chilling effect. So it's this, where there is a financial calculation made. And so then the more powerful the person, the more financial backing they have, the higher the risk of the story and possibly the hesitation around publishing.
It takes a lot of time and there's often a lot of argy-bargy between you and your lawyers.
And Kate says sometimes the effect of this is you soften the story.
So you do have to bear that in mind and think, okay, well, look, let's either remove that, soften it, take it out.
Has that ever felt a bit of a sting when you know what you've written is true?
Yes. Yes.
But the worst case scenario is that it gets spiked. The story never gets published.
Oh, I've been around the traps for a while and people know your work and know what you... It's not to say that people won't still sue or try to sue you or anything like that, but I think it's harder for younger journalists to often get their stories over the line.
What I was curious about was what happens when stories aren't spiked. You know, when things don't settle.
What happens if both sides don't back down?
Exactly. Well, it can get messy. And from Rebecca's perspective, it means...
Really, when it's required, going all the way.
But what does it mean to go all the way?
Well, it's to fight to the end. I mean, you know, when you have a very well-resourced media defendant, they will put you through the ringer. They throw the kitchen sink at you, they really do. And often it does require you to go all the way, which means going all the way to hearing.
Well, it was kind of tumultuous.
Josh Robertson is an investigative journalist with the ABC. Heston Russell sued the ABC, along with journalists Mark Willesee and Josh, over a story in 2021, which the court found implied the former commando was involved in the death of an Afghan prisoner.
My first reaction was sort of puzzlement about it.
Months had gone by since Josh's story had gone out.
Heston had been very publicly vocal in criticisms of the ABC and our reporting in that area. So I was familiar with him, you know, having a go, having a crack at us.
And that came in the form of, well, have a guess, Tom.
A legal letter?
That's right. And so I asked Josh, who was the correspondence from? Do you remember which law firm?
Yeah, I mean, from memory, I think it was Rebecca Giles' law firm.
Just over a month after receiving that notice, Josh found out he was being sued. And from that moment on, the case attracted a lot of media attention.
That sort of publicity around the case continued all throughout, and it kind of seemed like a war on us. That's what it felt like.
And what that case was, it was the very first public interest case.
Rebecca says her client tried everything he could to resolve it before he came to her firm.
He made editorial complaints. He publicly called for the ABC to review the matter. He couldn't have done more.
So what did the ABC say?
Well, an ABC spokesperson says the broadcaster took those complaints seriously, clarified one of the stories that Heston Russell was complaining about, and made a correction to the other. But Rebecca remains critical of the ABC's handling of the case.
I mean, I couldn't get a result for him before going to court.
So Heston Russell decided to take the ABC to court. The ABC argued it never intended to imply Russell was involved in wrongdoing, and so it didn't try to prove that he was during the trial. Instead,
they ultimately went to hearing on only one point only, and that was it was in the public interest to tell the story.
This new defence, the public interest defence, was brought in 4 years ago in most states. It was a big deal because defamation laws hadn't really changed in like 2 decades.
Yeah, right.
And what's interesting about it is that crucially, the media don't have to prove the story is true. They need to show they had a reasonable belief that the story is in the public interest. But that means they need to get into the witness box.
Yeah, getting up into the box, it was a really strange experience. You know, you have to go through these rituals of institutions with power that you're completely unfamiliar with as a layperson. You knew that you were being, you were on camera and you were sort of being beamed out on YouTube to whoever wanted to watch it. And there is an element of theatre in court. It's like inescapable. So it's not just a place for dry rational argument. You know, there's definitely a performative element to it.
And firing the questions was none other than barrister Sue Crisanto.
I'd heard from people who'd been in defamation cases before is like, get up there, don't say too much, say yes sir, no sir, and that's it. Don't answer any more than you have to. Now, I decided for whatever reason that I didn't want to do that.
At this point, I should probably add that Josh is also a philosophy graduate.
All that freaky post-war French stuff. That was my bag.
He decided to have quite an active discussion with Sue Crisanto in the courtroom, at one point even drawing on German philosopher Immanuel Kant.
I actually wanted to be more expansive and engage with the question in detail.
He didn't mind defending his journalism and having his process scrutinised, but the questions were coming thick and fast.
You've got these big folders, multiple folders of material, and so you get these rapid-fire questions from Sue about this or that, and you've got to refer, and she, they're speaking pretty quickly, and I just remember it was quite a race to try and what are you talking about? Where's this thing? So many numbers, letters, pages.
The judge ultimately found Josh to be an engaging witness and that the ABC genuinely believed the stories were in the public interest, but that it didn't meet all the criteria necessary for the defence, which requires that the belief was reasonable. In the end, the ABC was ordered to pay Heston Russell $390,000 in damages, plus interest and legal costs.
Right. So has that influenced Josh's appetite for doing big stories like this?
Well, Josh says going to court with big names like Rebecca Giles and Sue Crescenthu representing the other side hasn't changed his approach to his work, but he's now acutely aware of how a story might be tested in a courtroom.
I think it reminds you of how vulnerable you are if somebody with the money and the inclination wants to take you to court. Everything is going to be up for inspection.
Do you think, though, that could be argued that journalists should be doing that in the first place?
Oh, yeah, absolutely. It just reinforced the absolute importance of it because it's really the only thing that is going to be a bulwark in a legal setting. So not in a journalistic setting, but in a legal setting. It's another matter. Reporting journalism is regarded differently once you get into that sphere.
The new public interest defence was part of a package of reforms and it intended to shift some power back towards the media. But Rebecca and other lawyers had voiced concerns over the changes. She feels that when it comes to defamation law, it's the people she often represents who lack power.
When I say we have the worst defamation laws in the world, I don't mean because they're so onerous. I mean the opposite. It's so hard to vindicate your reputation within that framework.
But as I've discovered, it's not a perspective that all lawyers share. Matt Collins is one of the biggest names in defamation in Australia. He used to head up the Australian Bar Association and he's written books in this area of law.
So he knows his stuff.
Yeah, he really does. And so it was sort of a big deal when he said,
if it were up to me, I would throw our entire defamation laws out and start again with a blank sheet of paper. If stories are being spiked because of the fear that powerful individuals will bring crippling defamation actions against the media, that's a problem.
Matt has a pretty radical idea. The way it currently works is, say, if a media organisation gets sued and they want to prove the story is true, then it's on them to do that. And that's harder than it sounds because
there's a difference between something which is true in the ordinary sense of the word and something which can be proved to be true to the standards demanded in a court of law.
So Matt says, why isn't it on the plaintiff to prove it's false?
The cases I'm worried about are those where the plaintiff says, I'm suing you, you prove it. In those cases, I think the balance is tilted away from serious investigative journalism of the kind that is fundamental to the health of our democracy.
Why shouldn't the media have to prove what they have written is true or broadcast is true? I just don't understand the reason why the onus should be on the plaintiff to prove it.
Rebecca agrees the law needs to change, but not for the media's sake. Because in her mind, the media doesn't need more power.
I think you need to look at who's saying that. I mean, who covers defamation cases? It's the media. Who commentates on the defamation laws? Who publishes editorials on the defamation laws? It's not people acting for plaintiffs. So who stands to benefit from certain changes to the laws? It's the media.
So Tom, there I was, the media, reporting on defamation laws and the power in that. And then just a few days before we hit publish on this story...
Oh dear, what happened?
I was in the office working away. Next to me, once again, was BB reporter Marty Smiley.
What's going on?
So, just a few days out from our story being published, and I've just received an email to me and the executive producer of BB, and it's from Rebecca Giles.
So now you've got an email.
I've got a letter, yeah. So I'm going to go through that now.
All right.
All right, here we go. It's on the Giles George letterhead, and it's formally notifying Background Briefing of concerns Rebecca has about my approach with this story and some questions I've asked. It doesn't threaten legal action, and it includes several pages of editorial commentary. And it is
2, 3, 4, 5,
8 pages long. It reads well. It has thoughtful points about the power balance between plaintiffs and the media, and I can see Rebecca has put a lot of time into it, like she did with our interviews. But as this story shows, any letter from a lawyer is going to make a journalist jumpy.
This was the final episode of the Background Briefing series, Agents of Influence. If you haven't yet had a chance to, make sure you go back and check out the other 4 episodes in this series. And if you liked it, tell a friend. Background Briefing's sound producers are Lila Schunner and Ingrid Wagner. The sound engineer is Emrys Cronin, who also composed the music for this series. Additional production and research by Imogen Harper. Fact-checking by Imogen Tyndale. Our rollout producer is Ben Sveen. The supervising producers are Alex Mann and Annika Blau. And the executive producer is Fanu Falali. The reporter on this story is Gina McKeon. I'm Thomas Ariti. You can subscribe to Background Briefing on the ABC Listen app. Thanks for listening.